Someone just filed a domestic violence restraining order against you, or you filed a domestic violence restraining order against someone, and you want to know, can I get evidence against that person that they possess or that is in the possession of a police department, a hospital, or perhaps their employer? Hey guys, this is Vijay Dinakar, and I'm a California attorney who does a lot of domestic violence restraining orders. And if you want to know if you can get that information, the answer is California Family Code Section 6309 gives us that answer. That is a relatively newly enacted statute that was enacted in January 2024 that does provide specific and limited rights to get what we call discovery or evidence in domestic violence restraining order cases. Now, before that statute was enacted, and I remember that was only a little over 2 years ago, we're now in May 2026, there was a lot of confusion and a lot of disagreement among courts, trial judges, and attorneys in California as to whether you could do any discovery or get any evidence from the other side in a domestic violence restraining order. And that's because domestic violence restraining orders, unlike regular civil cases or unlike regular family cases, are expedited hearings, meaning when you file a domestic violence restraining order, by law, a restraining order hearing is set within 21 to 25 days. So as a practical matter, and that hearing is actually technically set for a contested hearing unless it's continued, as a practical matter, there's no time to do what we refer to as formal discovery. And what is formal discovery? Formal discovery in civil and family cases is doing a deposition, which is essentially bringing the other party to your attorney's law office to interview them or cross-examine them for an entire day, to issue what are called form interrogatories or special interrogatories, which are questions that are posed to the other party, or to get information that's being held by that party's employer, or that's being held by a police department, like a police report or a health record. Those are all obtained by what we call subpoena or a court order that information be released. So before, like I said, 2024, there was a single published case in California which gave some courts and some judges direction that discovery was essentially prohibited. And the case name was Thomas v. Quintero, and I'll have a link to it in this video. But it wasn't a domestic violence restraining order, but it did relate to what is called an expedited hearing in an anti-SLAPP case. And the court in that case said and suggested that discovery, because of the nature of an expedited hearing, was not something that was contemplated by the statute regarding discovery in civil cases, and that couldn't, as a practical matter, be completed. So there were a lot of courts and attorneys who relied on that decision to say discovery in domestic violence restraining order cases is simply not permitted. It doesn't happen, and no matter the cause, it can't occur. In those judges' opinions, the only way discovery could occur in domestic violence restraining orders would be if both parties consented to it occurring. And sometimes they would, because, for instance, let's say you had a domestic violence restraining order where both parties were seeking a restraining order and both parties thought that it was fair and that it would make sense for both parties to be deposed or have a deposition taken of them, so that when you actually did the trial, there wasn't going to be a lot of surprise. And so in those cases, the court wouldn't say you can't do a deposition. And so with mutual consent, that was occurring. Other judges took the opposite view. Because Thomas v. Quintero was not directly on point with respect to domestic violence restraining orders, they took the position that a domestic violence restraining order is a family court matter. And so, like other family court matters, normal rules of discovery apply. And they essentially allowed the domestic violence restraining order, to be continued until discovery was accomplished. The ambiguity and confusion about what discovery was permitted statutorily was ended with the enactment of Family Code Section 6309, which is what we're going to talk about today. Today, that statute specifically permits discovery can occur, but only with explicit court permission, meaning as opposed to a normal civil case where discovery is done between and amongst the parties without court intervention, without court permission, unless there's a need for court intervention because one of the parties allegedly is not complying with discovery and a motion to compel is filed. In a domestic violence restraining order, before any discovery can be obtained, the party seeking it must seek specific permission to conduct it from the court. And so the statute says that that specific permission or request can be done in writing or orally, and it can be done at the first hearing or a subsequent hearing. There really are no restrictions on the time limitation of when that request can be made, other than, as a practical matter, discovery cannot occur except without some formal limiting time period. So, for instance, to take the issue of a subpoena, you can't get a business or a police department to give you information in discovery through a subpoena without at least 30 to 45 days, usually about 2 months, before they're actually required to be compelled to release that information. Similarly, with a deposition, you're going to have to give them at least 30 days notice. So before you can actually conduct a deposition, get the transcript, have that ready, it's going to be approaching 2 months. So the optimal way to actually get discovery now with this new statute is in writing to file a brief and specific request to be heard at the first available court date, which might be the first court date, or the court may say, I'm going to hold another hearing on this request, but it should be done as soon as possible. Because unlike in normal civil discovery, the statute here limits and specifies the nature and kind of discovery request that can be conducted. And the court is told that it should find other ways to obtain this information, that it should be done in the least invasive manner possible. And that all goes to the purpose of the statute. So if you read the introductory preamble of the statute was enacted to remove the ambiguity about whether discovery was permitted. On the other hand, to limit specifically what discovery can be conducted in order to protect against potential what we call litigation abuse, especially when it's aimed at the alleged victim of domestic violence. However, the statute, although you may read the preamble and think otherwise, is not directed at specifically only allowing the alleged victim of domestic violence to conduct discovery or the respondent. Both can conduct discovery. And so it would be the very rare case that either the respondent or the person asking for the restraining order would not want to conduct discovery. If they are able to do that, they have the means to do that, they have the time to do that, they have the foresight to do that, you're going to want to do that. Because as a trial attorney, having handled dozens and dozens of domestic violence restraining orders, as well as over 40 criminal jury trials, I understand that trials are won and lost based on evidence that is collected before trial. So again, just to summarize, the domestic violence restraining order process in California now allows both sides to get information that is absolutely essential to winning the trial, and that's per California Family Code Section 63309. If you have a restraining order case, either you're requesting a restraining order and because you've been the victim of abuse, or you are facing a restraining order because someone has accused you of perpetrating abuse, you should absolutely request discovery. If you have any questions about domestic violence restraining orders and how to conduct discovery, please visit me at my website at vjlaw.com. Take care and all the best.